Hello, my name is Kevin Harrington, and I'm the co-chair of the Trust and Estates section. Welcome to the Trust, Probate, and Conservatorship Annual Litigation Update. Before we begin, we have a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in the BHBA Plus members only community. Please take a moment to complete the survey that is included with your certificate. Our next program will be on June 21st by Peter Stern, discussing AB 1194 and its changes to the law surrounding conservatorships. The Trust and Estates section is also accepting applications for positions on the executive committee. Anyone who is interested is encouraged to apply. Watch your email for more information on how to apply, as well as there'll be a link in the chat. If you have any questions regarding the positions on the executive committee, please feel free to reach out to myself or anyone on the executive committee. We also have a few words from our sponsors. I would like to introduce Brian Joy of the Sanborn team.
Thank you, Kevin. I'd like to take a minute to share a recent experience that may benefit you and your clients when it comes to selling properties off market and dealing with capital gains. Recently, we got the opportunity to list a property in Sunland. The seller is 104 years old, and because of her age, the executor is clearly considering options when it comes to selling her primary residence. They can either lease the property with the option to buy upon the owner's death, or sell the property and have the estate be liable for the capital gains taxes. Prior to us getting the listing, the estate received 2 offers for $800,000. We encourage the seller to list the property and allow for proper market exposure to ensure they weren't leaving any money on the table. They obliged and listed the property for $795,000. We had our first open house last Sunday and had over 250 people visit the property. We even got a visit from the police department due to the back of cars in front of the house. We believe the house will sell for well over $1 million, making the seller's decision of leasing with the option to buy versus selling and paying the capital gains tax much easier. It goes to show you that selling off market is not a seller's best path. On behalf of the Sanborn team, we sincerely thank you for your continued support. We truly appreciate our relationship with the Beverly Hills Bar Association and its members. Enjoy the meeting. Thanks, Kevin.
Thank you, Brian. We also have a few words from Orit Gadish of the Geffen Real Estate.
Thanks, Kevin. Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate. We specialize in representing trustees, administrators, and executors in the sale of commercial and residential real estate. We're focused on adding value for our clients, whether it's a partial or complete renovation. We first conduct our due diligence to determine the most appropriate value add solution, and then we execute with no cost to the seller until escrow is closed. We also have a designer on our team to ensure the properties we're selling are appealing to buyers and are drawing on their emotions to allow them to offer top prices. We're not a cookie cutter renovator. And if your chosen strategy is to sell as is, we do that too. On a different note, I'm the Vice President of Development for the Beverly Hills Bar Foundation. We have 2 events coming up. Please reach out to me if you're interested in sponsoring one or both of these events. We're working hard to raise funds for our scholarship fund, which helps law school students who are in need and are committed to careers in public interest law and are from traditionally underrepresented communities. The first event is coming up on Wednesday, June 8th at 5:30 p.m. outdoors at the Bonaventure Brewing Company in downtown LA. We plan on having about 250 attorneys, judges, and other legal professionals in attendance. Click on the link in the chat box to register. And our second event is the annual golf tournament taking place at Rancho Park Golf Course on June 24th. Feel free to reach out to me via text or cell. My number is in the chat box, and enjoy your program.
Thank you, Orit. In addition to the Sanborn team and Geffen Real Estate, the Trust and Estates is also sponsored by Glen Oaks Escrow. Marcine Klein is a full-service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of estates act. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that our clients are beyond happy with their experience at Glen Oaks Escrow. We also have California Title Company. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Lastly, we have Manufacturers Bank. Simplify your banking. Let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estates banking team with the experience to handle all of your banking needs. Contact Brian Flores, Vice President and Senior Relationship Manager, for more information. I will now turn the program over to our program co-chair, Andrew Smith.
Thank you very much, Kevin. It is my distinct pleasure today to welcome Nick Van Brunt and Scott Rahn to present the legal updates for this year. Nick Van Brunt is a partner of Sheppard Mullin and is the team leader of the firm's private wealth services team. Nick focuses his practice on resolving disputes over trusts, estates, conservatorships, and other fiduciary matters. His typical client matters include will and trust contests, breach of fiduciary duty cases, trustee accounting matters, conservatorship proceedings, elder abuse litigation, and cases involving the intersection between probate law and other legal issues. Nicholas is a member of the Executive Committee of the Trust and Estates section of the California Lawyers Association. He's also a member of the Executive Committee of the LA County Bar Association, Trust and Estates section, and served for 2 years as the chair of the Court-Appointed Counsel Liaison Committee, which is responsible for producing several training programs each year throughout Los Angeles County for court-appointed attorneys in conservatorship and guardianship matters. And Scott Rahn is the founding and managing partner of RMO LLP, a national probate litigation law firm with offices in Los Angeles, Orange County, San Diego, Ventura, Miami, Houston, and Kansas City, focused on representing beneficiaries, heirs, executors, and trustees in contested trust, estate, and probate litigation matters, and families and fiduciaries in contested conservatorships and guardianships. As one matter of housekeeping today, if you have any questions for our speakers, the chat window is closed, but you can still put these questions in the Q&A box. If there is time at the end, we will have our presenters answer the questions. If not, if we run out of time, please feel free to send any questions to them via email. And now it is my pleasure to turn it over to Nick and Scott.
Thanks, Andrew. Thanks, Kevin. Thanks, everyone, for having us again. It's always nice to get the band back together and get back out on this stage with Nick. I'm going to kick it off today. The first case that we're going to talk about is the conservatorship of Norma Ferrant. It's a case out of last year. It stands for the proposition that a court can order anyone who held a conservatee's assets to account, and an order compelling an accounting and ordering surcharge and sanctions is not going to be disturbed for failing to allow for an evidentiary hearing when no showing of proof or necessity was made. In Ferrant, the conservatee's son, her dutiful son, while acting as her attorney in fact, marshaled her assets for her, as any loving son would do, including her rental and Social Security income. The problem is he simply marshaled it for himself. The conservatee's the conservatee's daughter petitioned the court in the conservatorship action to force her brother, the attorney in fact, to account, which he repeatedly failed to do, or at least failed to do in some part, resulting in the court ordering him and sanctioning him $1,000 a day for every day that his accounting was late. Ultimately, after getting a partial accounting, the court, based on the evidence that was presented, ordered the attorney, in fact, the son, to disgorge $63,000 in money that he had taken from mom, the conservatee, and surcharged him another $63,000, essentially double damages, and then sanctioned him another $121,000 for his untimely failings to account as ordered by the court. And the attorney, in fact, appealed. And the issue on appeal was whether the court had abused its discretion in ordering him to account. He essentially said, you have no authority over me. I'm not part of the conservatorship. I was just somebody who's stealing my mom's money. And by denying him an evidentiary hearing, when he really didn't ask for one or make a showing of proof as to why he should have one. On appeal, not shockingly, the appellate court affirmed, said the trial court had not abused its discretion in refusing to grant him an evidentiary hearing because he had made no showing of proof. He hadn't asked for one, much less offered to inform the court what he intended to present. And this is an ongoing theme. We tend to see this issue arise in cases. You'll hear about it in another one of the cases that we're going to review for you guys here today. And if you're not going to make that showing, if you're not going to at least make an offer to the court's unlikely to give it to you. And the court also said, look, anybody who has money that belongs to the conservatee or belonged to the conservatee can be made to account. Doesn't matter what position you're in. And that case was upheld. The next case that we have is Hudson v. Foster. And this deals with an issue regarding a conservatee, but it could really apply to any beneficiary, and the notice issues that pertain specifically to petitions, objections, but it could apply to statute of limitations, and whether the fiduciary role that someone who's perhaps hiding information may play in protecting your rights to pursue those claims. So in Hudson v. Foster, the conservatee was injured in a car accident, and the conservatee, his counsel, his personal injury lawyers, got him a $10 million settlement. The net proceeds of which were funneled into the conservatorship estate and managed by the conservator, who was the conservatee's friend. Also a theme. We had the dutiful son, and now we have the dutiful friend. In the conservator's first and final account, as the conservatorship was wrapping up, he detailed 28 checks totaling more than $500,000 that he represented in his accounting were payments made to the conservatee's creditors. In reality, the checks were cashed by the conservator, who in his accounting had waived any compensation. So no good deed. Shortly after the accounting was approved, the conservatee began to receive calls from creditors, and they wanted their money. And the conservator said, no, you've already been paid. This was all part of the accounting. The conservator paid you guys, and they cleared the air, the creditors and the conservatee. And for the first time, he learned that the conservator had misrepresented the contents of the accounting. So the conservatee filed a motion to vacate the order on the final account on the basis of extrinsic fraud on the court, which the trial court denied on the basis that the conservatee had had the opportunity in response to the accounting petition to object and say, no, this isn't right. And the conservatee appealed. And the issue on appeal was whether the court had abused its discretion in failing to vacate its order on the petition approving the accounting, where the conservator had misrepresented the contents of that accounting, misrepresented the payments that he had allegedly made, with no, and this is important, obviously, with no knowledge of the conservatee, right? Who wouldn't have known if this guy had paid the creditors or not, because the conservatee was handling it, and the conservator had represented in the accounting that he had, in fact, in a duly sworn submission, verified by the conservator that he had, in fact, made these payments. The result on appeal was that the appellate court reversed and remanded, overturning the order approving the accounting with an instruction to the trial court stating that due to the fact that the conservator, who serves as a fiduciary, owed a duty to the conservatee, as well as to the court, frankly, to be honest and forthwith in presenting his accounting, and because that duty that the conservatee, and because the conservatee had no duty to investigate the veracity of the representations being made by the conservator, there was no indication that any reasonable person should have been put on notice that they should have investigated, which is what the trial court said he had a duty to do. So in this case, the order was vacated and the matter was resubmitted.
Sometimes the good guys win.
Sometimes.
So we've got two cases that come to different conclusions about the interplay between the statute that deals with the procedure for revoking a trust, which is Probate Code Section 15401, and the one that deals with modifying a trust, which is Probate Code Section 15402. And those two cases are Haggerty versus Thornton and Balistreri versus Balistreri, and I'll talk about those in turn. Before we do that, just to give a little bit of background. So what Probate Code Section 15401 provides is that a revocable trust may be revoked either by compliance with any method of revocation provided in the trust instrument, or by a writing other than a will that is signed by the settlor or any other person holding the power of revocation and delivered to the trustee during the lifetime of the settlor or the person holding the power of revocation. But if the trust instrument explicitly makes the method of revocation provided in the trust instrument the exclusive method of revocation, then the method in the trust instrument must be used. So that's 15401. 15402 governs modification. And what 15402 says is unless the trust instrument provides otherwise, if a trust is revocable by the settlor may modify the trust by the procedure for revocation. Now notice all it says is unless the trust instrument provides otherwise. There's nothing about exclusivity. So now let's talk about the Haggerty case with those two statutes in mind. In Haggerty, Jean Barch executes a trust, which she amends in 2016 in favor of her niece, Brianna Haggerty, who was the appellant. Thereafter, Jean executes two additional documents where I guess she was less happy with Brianna because she disinherited her. Neither of those documents complied with the specific provisions for amending and revoking the trust that were set forth in the instrument, but they otherwise complied with the probate code requirements for amending and revoking trusts. The trial court found that the decedent's failure to comply with the trust's non-exclusive method for amending or revoking the trust was not fatal, where she complied with the probate code requirements by amending the trust in a signed writing delivered to herself. Brianna appealed, but the Court of Appeal affirmed. And in the appellate argument, both parties focused on the seminal case of King v. Lynch. In King v. Lynch, a married couple had created a revocable trust that described separate procedures for modification and revocation. The trust could be modified, again, by a writing signed by both settlors and delivered to the trustee, but could be revoked by either settlor in a signed writing delivered to the trustee and other settlor. One of the spouses in King v. Lynch suffered a serious injury, and then the other spouse took that opportunity to execute several trust amendments unilaterally. In King, the majority opinion held that these amendments were invalid because while 15401 states that it applies unless the trust instrument makes the method exclusive, 15402 simply says that its provisions apply unless the trust provides otherwise, and the trust provided otherwise. So the dissenting justice in King, however, explained that the legislative history of 15402 suggests that it was not really intended to be more restrictive than 15401, but was supposed to apply the same flexible rule. But the Haggerty court, looking at all that, comes back and says, well, King's distinguishable because the trust instrument here states that the settlor had the right by an acknowledged instrument in writing to revoke or amend this agreement or any trust hereon. The trust instrument did not distinguish between revocation and modification, did not provide that the standard for modification was different than the standard for revocation, and therefore the statutory method for revocation applied to the procedure for modification. And so by signing an amendment and delivering it to herself as trustee, Jean effectively disinherited Brianna. Notably, the Court of Appeal there opined that, quote, as a general matter, the King dissent more accurately captured the meaning of 15402, which was that the method of modification should be the same as revocation, barring a contrary provision in the trust. But the case did not officially overrule King v. Lynch, which for the moment remains the law of the land. Petition for review has been granted on Haggerty. That is now before the Supreme Court. Enter the case of Balistreri. Balistreri, rather. In Balistreri, you have surviving spouse Mary, who seeks to file a petition to validate an amendment to a revocable trust, which she and her husband Sal amended the day before Sal died. Now that instrument provides, quote, any amendment, revocation, or termination shall be made by written instrument signed with signature acknowledged by a notary public by the trustors making the revocable amendment or termination and delivered to the trustee. And so Mary and Sal signed an amendment that would have caused certain gifts that would have gone outright to their children from their respective marriages, prior marriages, to instead be held in trust. But that amendment was not notarized. And so the probate court said, well, yeah, it wasn't notarized, null and void, and denied the petition, and Mary appealed. And the Court of Appeal affirmed. And the Court of Appeal in Balistreri took the King v. Lynch approach. The court said specifically that unlike Probate Code Section 15401, 15402 provides, again, that unless the trust instrument provides otherwise, the settlor may modify the trust, but here the trust provided otherwise. Now, the court was interestingly cognizant of Haggerty and said that the Court of Appeal had the majority, I should say, had no, quote, quarrel with most of Haggerty, but the Court of Appeal disagreed with the conclusion that the trust instrument needed to provide explicitly that its method was exclusive for the default language in Section 15402 to apply, because 15402 plainly states that only if the trust does not provide otherwise does the method for revocation in 15401 govern. There was no ambiguity in the trust clause. That's the end of the story. There's a concurrence in Balistreri. Justice Tucher concurred in the ruling, but not the reasoning. Because the language in the trust amendment referred to any amendment and had the term shall, Justice Tucher read the provision as exclusive, and that the court did not need to reach the issue of whether Section 15402 precluded any other method. However, Justice Tucher noted that if a method for modification set forth in a trust did not explicitly or implicitly limit trustors to that method, then it would seem that that method for revocation in 15401 should be permitted for modification. But he would not go as far as Haggerty, which held that any authorized method of revocation may be used to modify the trust. So in other words, it's all clear as mud right now. I'm sure everything will become clear once the Supreme Court hears this, probably later this year. Review has been granted on Balistreri as well, but its briefing is being deferred pending consideration of Haggerty.
And a takeaway for all you planners out there, if you intend for a method to be exclusive, just make it exclusive and say this shall forever from now forth be the only method by which you can do this. And then you don't have to worry about all these other things.
Yeah, maybe even use the word exclusive. Yeah.
Next case that we have is Law Finance Group versus Key, and this is the latest round in the Key versus Tyler saga. Key is fresh off her victory against her sister, Tyler, who she had disinherited for her undue influence of mom, and Key, apparently, in pursuing her sister for all the years that they pursued one another, was financing that litigation using a litigation finance company. That's where Law Finance Group comes in. The Law Finance Group had fronted about $2.4 million to Key in her pursuit of her sister. And after being successful at trial, Law Finance Group wanted to be paid. So while Key was happy to pay Law Finance Group the principal that it had advanced, she took issue with the interest charges that the company charged, which tend to be significant, claiming that it violated California's usury laws. The matter went to arbitration. The Law Finance Group agreement had an arbitration clause, which is pretty standard. And the finance company prevailed for the most part and was awarded nearly $750,000 in interest plus $850,000 in attorney's fees and costs. Law Finance Group then sought to confirm the arbitration award, to which Key filed a motion to vacate, but she filed it 130 days after they filed their petition to confirm. Despite her procedural deficiencies, because she filed it 9 days late, and a motion to vacate has to be filed within 100 days. I'm sorry, so it's 30 days late. The court vacated the arbitration award and the finance company appealed. And the issue on appeal was whether Key's motion to vacate the arbitration award was timely. And the appellate court said it was not and reversed and remanded, confirming that a motion to vacate has to be filed within 100 days from service of the award. And here Key had filed her motion 30 days after that deadline had expired. Although review has been granted on that case as well, which means Key v. Tyler and that saga continues to rage on, as you'll see with a couple of our cases here today. The next case that we have is the estate of Wall, and Wall is a really interesting case. If you haven't had a chance to read it, I suggest you do. It deals with the interplay of Family Code Section 760 and 721 and the presumptions of community property and undue influence between spouses and community property transactions. And the finding in this case that those presumptions trump the evidence code section 662 form of title presumption, unless those presumptions can be rebutted. So in the estate of Wall, the decedent husband and surviving spouse purchased a home that was financed solely by the deceased husband with title taken in his name alone. The surviving spouse executed a quitclaim deed disclaiming any interest in the property as well. The surviving spouse, the wife, had made some small monetary contributions to the property, but otherwise the mortgage payments, the maintenance, property taxes, etc., were all paid from the decedent husband's separate property assets. There was no dispute about that. But after the husband passed, the surviving spouse filed a spousal property petition claiming the property was community, despite it being titled in his sole name. The decedent husband's children objected to that petition and took issue, claiming that the presumption of title, again, the decedent had taken title in his own name, under Evidence Code 662 was dispositive. The trial court, however, disagreed. And the trial court disagreed in part because the surviving spouse, the wife, had obtained testimony from the mortgage broker, the real estate broker, as well as her own testimony, evidencing that it was their joint intent to own the property together, despite the titling. In essence, they presented evidence to rebut that presumption. And then she further relied on Family Code Section 760, which again is a presumption of community property, and 721, which is the presumption of undue influence among spouses. And the decedent's children appealed. And the key issue here again was whether the form of title presumption found in Evidence Code Section 662 or the community property and undue influence presumptions found in Family Code Sections 760 and 721 were going to control disposition of this property. The appellate court, in relying on in re the marriage of Valley, affirmed the trial court's order, finding that the Family Code sections regarding the presumption of community property and the presumption of undue influence among spouses applied in this context in determining what the community property rights of the couple were. And importantly, the appellate court paid special attention to the fact that the children had presented no evidence to rebut those presumptions. So in the wake of the evidence that was in front of the court and the wake of the evidence that was in front of the appellate court, there was nothing to rebut the presumptions that the surviving spouse had advanced, while the surviving spouse had rebutted the presumptions that the children sought to advance. Interesting case and interplay of family code and evidence issues that we see regularly.
And continuing the theme of spouses having fun with property presumptions. So in the case of Pierce v. Briggs, the issue was, is a joint tenancy interest severable by a will when there is no clearing unequivocal severance and no recordation of the will? Objection leading, and the answer is no. So Ruth and Charles were married in 1949. When they married, Ruth already had two biological children, Everett and Flora. And then after they married, Ruth and Charles, also known as Jack, adopted three children, including Margaret, Teresa, and Charles Jr. And then Ruth and Jack bought a property known as the Gibson property, and they bought it as joint tenants. They then conveyed a 12.5% interest to Jack's sister Marie, leaving the remaining 87.5% in joint tenancy. Ruth then executes a will. And that will includes a provision that all property owned by Ruth and Jack, including that which was held as joint tenancy, was actually intended to be community property, and that her community property share would be distributed according to her will. Ruth then dies, Jack is still alive. And then after Ruth's death, against the advice of counsel, Jack refuses to probate Ruth's will. Jack then executes a will, leaving his estate in 5 equal shares to the 5 children. And then again, against the advice of counsel, Jack executes an affidavit of joint tenancy concerning the Gibson property, which is the property that Ruth had said was intended to be community property and should be distributed according to her will. Jack then executed a living trust in favor of only the later kids and put the Gibson and Rosedale properties, which is another property, into the trust, and then Jack dies. Everett and Flora, who were aced out of Jack's living trust, on the one hand, and then Charles and Margaret, who are the surviving kids who did benefit from Jack's trust, on the other hand, filed competing 850 petitions. The Pierce parties, who were Everett and Flora, argued that a will had a dual character as both a will and, quote, something else at the same time, and that the joint tenancy was immediately severed upon execution of the will because a testator otherwise has no power to dispose of a joint tenancy property by will. The Court of Appeal was unpersuaded, and the operative language in Ruth's will was as follows, quote, I declare that for convenience or through inadvertence, title to some property owned by myself and my husband may be held of record in the form of joint tenancy, but that all such property is in fact intended to be our community property. While that's a statement of intent, the Court of Appeal found that that language did not reflect a clear and unequivocal intent to sever the joint tenancy at the time of execution. The language was really non-specific. It didn't even refer to the Gibson property, and it didn't demonstrate an intention to, again, unilaterally sever the joint tenancy. Another interesting issue is that, wills only become effective immediately upon execution if they are contractual in nature, like a joint will, because then they become effective immediately in a contract. Otherwise, a will is revocable until the moment of death, and therefore it's not effective until that point. So even if the language had been clear and unequivocal in the will, Civil Code section 683.2, which I know you all have committed to memory, requires an instrument severing a joint tenancy must either be recorded prior to the death of the joint tenant or within 7 days after death, if notarized. And of course, 7 days after death of a loved one, everyone's thinking of making sure that they immediately get that will recorded with the county. But further, there was also no agreement between Ruth and Jack to transmute the joint tenancy to community property. So the bottom line is, if you want to terminate a joint tenancy in a will, maybe find another way. But if you're going to do it that way, make sure you comply with Civil Code section 683.2.
It's a good one where it seems like they were trying to do the easy thing the hard way.
Yeah, well, it's like Jack didn't listen to his lawyers twice and got away with it. So I don't know what the lesson is there, but that's probably the takeaway.
Never happens to me. I'm sure it never happens to you either. The next case is Ring v. Harmon. This is a particularly sad case for any of those of you who have grandparents or elderly parents and the things that can happen to them. And Ring stands for the proposition that standing to assert a financial elder abuse cause of action exists in special circumstances where, for an individual where the abuse was committed against the person in their fiduciary capacity, but the injury that they suffered is personal in nature in a beneficial interest. So the background in Ring v. Harmon, mom is 80 years old. She loses her daughter and she is named as the beneficiary under her daughter's will, and she's also named as the executrix. Her son and grandson, again, being dutiful, seek to have and help mom get appointed as the executor of her daughter's estate. And then once appointed as executrix, mom, again, at the urging of her son and grandson, along with the son's buddies who run the finance company, encumber the daughter's home. And the house is worth about $400,000, had about $100,000 in debt on it. They had mom take out a note for $200,000 at 10.99% interest only, which was scheduled to generate about $110,000 in interest payable over 5 years. At the end of that 5 years, mom would have a $201,831 balloon payment that would be due. And if she failed to make any of those payments, there were significant default penalties. They also charged her $18,000 in fees. At the end of the day, after all the fees and everything came out of the financing, there was about $40,000 that was left, that was put into the estate account, which her son and grandson swiftly stole. Mom, a bit frustrated, sued her son, her grandson, her son's finance partner individually, claiming that the loan and the resulting encumbrance on the property were the product of predatory lending and financial elder abuse, among many other things. The defendants demurred to mom's complaint because she had sued in her individual capacity and not in her fiduciary capacity. And the trial court originally sustained that demur, and mom appealed. And the issue on appeal was whether an elder, in this case, who's both beneficiary and fiduciary of an estate, has standing to assert a claim for financial elder abuse in her individual capacity, where the injury at issue was incurred in her fiduciary capacity. So the appellate court here reversed and basically said mom had no authority to assert a claim for financial elder abuse on behalf of the estate, and because it had suffered no harm, and because she was the beneficiary and fiduciary, a claim against herself, right, suing herself as sole beneficiary, where she's the sole executrix, wasn't really the answer. Therefore, mom's special circumstances justified her bringing an action for elder abuse in her individual capacity, despite the fact that the alleged bad acts that caused the harm were really related to her role as fiduciary. Separately, the court also found that her financial elder abuse claim did not require her to hold title to the damaged property in her individual capacity, because her beneficial interest was harmed by the debt that had been wrongfully secured and predatorily put on the property. So mom is going to win at the end, but what a terrible way to get there.
Yeah, it's never fun when your case gets delayed, particularly when you're an elder, by 2 years in the Court of Appeal.
Yeah.
Speaking of standing, it's a new case that just came out from Judge Small's courtroom, Department 5. It's a Autonomous Region of Narcotics Anonymous versus Narcotics Anonymous World Services. This is actually a case of first impression in that it deals with a charitable revocable trust and whether there is a standing on behalf of one of many Narcotics Anonymous collectives to sue, and the answer was no. It's a very interesting decision. So in Autonomous Region, the Fellowship of Narcotics Anonymous, which we'll call the Fellowship, is a, quote, amorphous group, close quote, that is the named settler of this revocable charitable trust that holds and governs the intellectual property of Narcotics Anonymous. In the trust instrument, the fellowship is referred to as the settlor in a singular, using the term singular, and that becomes important, although it gets its, quote, collective voice from the various groups who are members of the Narcotics Anonymous Fellowship. A group called the Autonomous Region of Narcotics Anonymous, the Autonomous Region, alleged that the trustee of the trust, Narcotics Anonymous World Services, breached its fiduciary duties in various ways and filed a petition for redress associated with those breaches. The fellowship actually demurred on the ground that the Autonomous Region lacked standing to sue. In opposition, the Autonomous Region argued that it did have standing because it was effectively a settlor with the power to revoke the trust as one of the tones in the collective voice, if you will. And two, it had special interest standing under Holt and some other cases, which we'll talk about in a minute, to sue to enforce the charitable aims of the trust. The trial court sustained the demur, the autonomous region appealed, and the Court of Appeal affirmed the sustaining of the demur. And the key issues are really two. One, can the trust be construed to treat the autonomous region as a settlor of the trust, providing standing? And two, if not, can the autonomous region properly plead, quote, special standing? And the answer to both questions was no. With respect to the question of whether autonomous region was a settlor, the Court of Appeal held that pursuant to Probate Code section 15800, which governs revocable trusts, the person holding the power to revoke is the person to whom the duties are owed, effectively the settlor. While the autonomous region claimed that it had standing because it was one of multiple members of the collective voice, the trust was unambiguous that settlor was singular and that the fellowship was the settlor, and that it gets its voice through these regional delegates. But the trust also provided that a 2/3 vote of those regional delegates could remove a trustee. And so the corollary of that is, if no one delegate can even fire a trustee, how could one delegate have the power to revoke a trust? So it doesn't make sense that they're effectively settlors for the purpose of standing. And further, the trust instrument itself forbids a single group within the fellowship from acting alone to do something that affects the entire fellowship. So the Court of Appeal didn't really mince words. It said it would be a, quote, absurdity to treat the autonomous region as a settlor for purposes of standing. Now, with respect to the second question concerning special interest, there's a case called Holt v. College of Osteopathic Physicians and Surgeons. And that case changed the longstanding rule before 1964 that only the Attorney General had standing to seek redress from an irrevocable charitable trust. Justice Traynor in Holt sought to solve, quote, the problem of providing adequate supervision and enforcement of charitable trusts, and therefore conferred standing upon a co-trustee of that trust to sue. And the thought being, the Attorney General doesn't have the resources to deal with every single charitable trust. They may not know about what's going on. You can't have a situation where an irrevocable charitable trust really has no effective check. And so it was appropriate for a co-trustee to be involved. That special interest concept has expanded in other cases. One is San Diego Boy Scouts versus City of Escondido. And in that case, the Court of Appeal found that the San Diego Council of Boy Scouts of America and the parent organization and the governing board were permitted to bring a suit on behalf of the Boy Scouts of a particular district in its jurisdiction when they were beneficiaries of a charitable trust where the City of Escondido had been asserting title to property that was supposed to have certain use provisions for the Boy Scouts. So this is an expansive idea in the context of a revocable charitable trust. But even in Holt, Justice Traynor noted the potential for, quote, vexatious litigation and distinguished between members of the public who have no particular standing and maybe fiduciaries who are both few in number and charged with the duty of managing the charity's affairs. And again, the difference in those cases, both Holt and Boy Scouts, was that the trust was irrevocable. There was no settlor there to protect the charitable aims. In the Narcotics Anonymous case, that's different because you do have a settlor. It's this fellowship. And this fellowship is providing supervision and enforcement over the trust. And that fellowship is distinct from the trustee, who's World Services. So for that reason, the Court of Appeal affirmed the lower court ruling and also held that the Probate Court had denied leave to amend properly because there was no way to demonstrate that the autonomous region had standing. It's a really interesting case.
The next case deals with Medi-Cal reimbursement, and it's Riverside County Public Guardian versus Snoops. And it deals with the proposition, it stands for the proposition that the California Department of Health Services can recover reimbursement from a decedent's revocable trust for Medi-Cal benefits that were paid to the decedent. In Snooks, the decedent had created a revocable trust shortly before he passed and named his niece as a sole beneficiary. He had named that trust as the sole beneficiary to an annuity that he had. But prior to his death, he had received approximately about $500,000 in Medi-Cal benefits, which the California Department of Health Services, Healthcare Services sought to recover after he passed. The department had filed a creditor's claim, which the public guardian sought to pay. The probate court denied that request for approval and ordered the assets paid to the decedent's niece, and the department appealed. And the issue on appeal was simply whether a decedent's revocable trust assets are responsible for reimbursing monies paid for Medi-Cal benefits that were received by decedent prior to their death. And the appellate court said yes, and reversed, finding that not only do California and federal law, but the public policies underlying those laws provide for an extraordinarily broad definition of the term estate when considering the issue of reimbursement for Medi-Cal, Medicare benefits paid. And that definition is necessarily broad enough to include all assets in which the recipient of those benefits may have had an interest during their life, including, specific to this case, assets placed in a revocable trust. The goal here being that these programs can recover assets post-death so that they can continue doing the good work and providing the benefits that they provide to the public.
I'm going to move on to the latest anti-SLAP case involving no contest clauses. This is Dave B. Traver. Just the outset, there's a great article in the recent California Trust and Estates Quarterly entitled "When We Don't Clap for Anti-SLAP," I think is what it's called. And there's also a podcast at the CLA website, which I would recommend to you. Anyway, Dave V. Traver. A motion to strike a petition to enforce the no contest clause under the anti-SLAP statute was properly denied when the petitioner demonstrated a probability of prevailing on the no contest petition. So in this case, Day filed a petition to challenge Robert's conduct in setting up a financial structure that Robert claimed was designed to avoid estate taxes and had the incidental effect of removing Day entirely as a beneficiary of the trust. Robert claimed that Day's petition would implicate the no contest provision of the trust that became irrevocable prior to 2001, so it's under the old no contest law, because it would impair provisions in the trust giving the trustee authority to manage assets, and that was effectively a contest. Robert also claimed that the trustor had intended to allow the trustee, him, to change the beneficiaries, and that the petition violated the no contest clause for that reason as well. And so Robert accordingly filed a petition to enforce the no contest clause. Day then files an anti-SLAP motion, arguing that his petition came from protected activity and that Robert's petition did not have minimal merit. And the trial court denied the motion, and Day appealed, thereby staying proceedings for a lengthy period of time. The Court of Appeal affirmed the trial court. And again, the anti-SLAP motion analysis, you look at two different prongs. First, does the pleading in question seek redress for the moving party engaging in protected activity? And two, if it does, then is the challenged claim based on protective activity legally sufficient and factually substantiated? Is there minimal merit to the claim? Now, it's undisputed that petitioning the court to redress Robert's actions was protected activity. So you have to really look at the minimal merit prong, which is the second prong. And the Court of Appeal agreed with the trial court that Robert had demonstrated minimal merit to show that Day had filed a contest because Day specifically challenged his removal as a beneficiary of the trust that the settler had established for life insurance proceeds. And he also challenged the related decisions by the trust, which could reasonably be read as impairing the trust for purposes of this pre-2001 no contest clause. Now, because Day sought to limit the discretion of the trustee, and because this would have the effect on how certain beneficiaries would receive assets from the trust, there was at least a probability that Day's petition constituted a contest and the motion was properly denied. The Court of Appeal was careful to note that it was not deciding whether the no contest petition itself should be granted, but merely that it should not be stricken for lack of minimal merit. But think about how you might feel if you're Day's counsel at that point when you have a ruling from the Court of Appeal that says, well, I'm not saying that it's definitely a no contest clause violation, but it might be. That's probably not a comfortable conversation with your client. Anyway, one justice did dissent, concluding that the trust was unambiguous that Day had an irrevocable remainder interest in the trust. And that dissenting justice also said that the trust instrument did not authorize the trustees to alter, revoke, or modify the gift to Day, and therefore Day is seeking redress for the trustees effectively disinheriting Day did not constitute a contest. Day did file for review by the California Supreme Court, but that petition for review was denied. Switching gears, we're going to talk briefly about special immigrant juvenile status case, SHR Rivas, which is currently also on its way to the Supreme Court. In Rivas, you had a minor who was seeking judicial findings that would enable the minor to have special immigrant juvenile status under the federal immigration law. And the trial court and the Court of Appeal affirmed, said that the minor failed to demonstrate in the minor's prior country abuse, neglect, or abandonment by a preponderance of the evidence, which is the standard. Just a little bit of background, special immigrant juvenile status, or SIJS, is a federal immigration status that's given to unaccompanied minors who enter the U.S. without documentation, and they will have either suffered abuse, neglect, or abandonment by their parents, and its reunification with that parent or parents is not viable. The applicant typically only needs to show abuse, neglect, or abandonment, not all three, and it can be from only one parent. Why is this in probate court? Well, the probate court typically issues these findings in connection with a guardianship proceeding, and so that's why it falls within the probate court's jurisdiction. So anyway, the minor arrives from El Salvador in 2018, moves in with his cousin's husband in Palmdale, and then files to appoint his cousin's husband, Rivas, as his guardian, and subsequently files for SIJS findings. The minor, from the time he was 10 until he was 15, worked in the fields in his home country of El Salvador up to 7 hours a day, supporting his family. And then when he refused to join a gang in 9th grade, his parents made him stop going to school for fear he'd be killed there, and forced him instead to work in a car wash, where he saved enough money eventually to get to the United States. He alleged that his parents had neglected him by failing to provide for his welfare, forcing him into child labor at 10 years old. The court denied the petition, ruling that it was not neglect under California law, and that reunification when one or both parents was in fact viable. A minor appealed, and the Court of Appeal affirmed. The order denying the SIJS application was indeed final and appealable. That was one issue that was dealt with by the court, but the minor had the burden of proof at trial, and the standard of review in the appellate court was whether the evidence was, quote, uncontradicted and unimpeached, and, quote, of such a character and weight as to leave no room for judicial determination that it was insufficient to support a finding. So basically substantial evidence. That's a tough hill on appeal. The minor argued that the role of the Superior Court was actually to determine whether there was evidence that could support a ruling in favor of the petition, but the Court of Appeal disagreed, citing Section 155 of the Code of Civil Procedure that requires factual findings, and that federal law actually requires that evidence show that the juvenile was actually subjected to parental maltreatment. And the Court of Appeal further found that spending 6 to 7 hours working every day as a child may violate child labor laws, but was not per se neglect when the minor was helping to earn money for an impoverished family. And similarly, the decision to pull a child from school to avoid death threats from gang members was not neglect. And the fact that his parents were unemployed is not neglect without more, and that the minor had also failed to show that reunification was not viable based on the foregoing. Honestly, I don't know how I feel about that result. I don't know if it's appropriate for me to get into that here, but I have been involved with several SIJS cases, and my experience is that where a minor is being subjected to child labor and prevented from obtaining an education at the behest of their parents, courts have generally accepted this as supporting a finding of neglect for purposes of SIJS, and given that the Supreme Court has granted review, it'll be interesting to see what happens. I know there's a lot of amicus work going on right now with a lot of the organizations you'd expect, so stay tuned on that.
We've got about 5 minutes left, and we've got 5 cases, so we're going to try skipping through this in lightning round fashion to make sure we get a chance to touch upon all of them. First, I'm going to cover three, and then Nick's going to close for us. The first that I have is a case dealing with rescission and the issue of unilateral mistake. It also touches on mutual mistake. It's the estate of Escra. It just came down a couple weeks ago at this point. And essentially stands for the proposition that where a party is to blame for their own mistake, here where the widow had failed to read the prenup that she signed and failed to consult her attorney about the final version of the document that she signed, the court essentially isn't going to save you on the basis of unilateral mistake, because as I highlighted, you essentially are to blame for it. It's a pretty quick read. Essentially, the widow and her decedent husband entered into a premarital agreement. Prior to finalizing that agreement and signing it, they had some discussion, and what she thought was an understanding that the prenup would only apply during divorce and not at either of their deaths. She and her husband had that discussion. He then went back to his lawyer and essentially, according to the lawyer's testimony, said, look, I just want to make sure I'm protecting my daughter. You know, you can work it out with the other lawyer. It didn't get worked out with the other lawyer. The death provision remained in the document. It got finalized. The widow did not meet with her lawyer prior to finalizing it, did not read the document, just walked into the lawyer's office and signed it. And then when she came to find out that she wasn't getting anything, sued and then lost and then appealed, claiming unilateral mistake, which the court said she can't carry the burden on that because she didn't do enough to protect herself, and she can't carry mutual mistake because it was clear that the husband didn't intend to take out that death provision. Pretty quick read, but importantly, more interplay with the family law codes, like Estate of Wall. The next case is White v. Ware, which, like Key v. Tyler, seems to be a bit of a saga, as Nick and I were talking about in prepping for this. And in White v. Ware, the latest iteration of this case deals with an issue of an elder abuse restraining order, and what the court can and can't do to essentially help a restraining order along. In this case, White, who is the conservatee's daughter, sought an elder abuse restraining order preventing her father's stepdaughter from continuing to interfere in her stepfather's affairs. The petition for the elder abuse restraining order was unopposed. The perpetrator of these bad acts failed to appear, failed to object. The court granted the restraining order, rightfully so, and in doing so, clarified some of the allegations that were being made and the reasons why the relief was being sought, but also extended the relief that was sought in that petition to include a prohibition from the perpetrator carrying firearms or ammunition. And after the order was entered, the perpetrator, Ware, appealed, basically saying that you can't expand, you can't help them. Basically, you can't clear up the allegations, you can't expand the relief requested. And oh yeah, by the way, after the order was issued, I filed a 170.6 dinging the judge related to another matter, and he recused himself, so he's inherently biased, and this order therefore is void. And the appellate court said, nope, except for the issue of expanding the relief to include a prohibition of carrying firearms and ammunition, the order is as good as done and dusted, and affirmed mostly, but reverse that small part of it. The last case I'm going to cover reminds me of my old Civ Pro teacher. I know Nick's heard this before. There's nothing new about international shoe when it comes to jurisdiction. Well, there's nothing new when it comes to Chew versus Chew. Chew is a case that I'm sure has touched many hearts in this community. Certainly has come across various desks. But the latest iteration deals with a settlement agreement, and the issues here in Chew deal with enforcing settlement agreements and the limits of Probate Code Section 259, dealing with elder financial abuse. It's not a quick read, it's a long read, but essentially in this case, Christine Chew, who is the protagonist for much of the shenanigans that are involved in these cases, essentially entered into a settlement agreement on the record before Judge Cowan, who many of you knew, and subsequently, about 2 months later, sought to rescind her approval of that settlement agreement, claiming that the agreement was legally invalid because she was under the influence of codeine and she wasn't feeling well and she was sleep deprived and the dog ate my homework and I was abducted by aliens. I kid on the last couple. But she threw up whatever defenses she could to try to invalidate that agreement. Eventually, an agreement was entered into by the court with all the parties except her. It was approved by the court, and she sought to appeal that order. And the appellate court affirmed the trial court's approval of the settlement agreement. There's a long discussion. Essentially, the core issue here was that Ms. Chu and her children had claimed that the settlement was unconscionable, either substantively or procedurally, and the court disagreed. On the procedural issue, the court essentially said that while Ms. Chu claimed that she had asked for an evidentiary hearing, she had not. Again, going back to the issue that I had raised earlier in this presentation, if you don't ask for an evidentiary hearing, and if you don't make a showing of proof, you're not going to get to complain about it later for having not gotten one. As far as the substance of it, Ms. Chu had argued that even if she was disinherited under Probate Code Section 259 for financial elder abuse, that her share of the estate essentially would go to her son. And because the settlement, therefore, the settlement was worse than what her son and daughter would have gotten if she had gone to trial and lost, the court said, no, your analysis is wrong. That's not the way 259 works, right? 259 limits what you get, but it doesn't add to what someone else gets. So your son, your daughter would not have necessarily gotten what you would have lost. So the settlement was not substantively unconscionable. Good read, good discussion of a lot of different issues, but make some time for it.
Yeah, it's definitely a good read. Sorry, I saw in the Q&A that apparently my audio has not been up to its usual standards. I do have a new computer, so I apologize for that. We're just about out of time. There are two cases in the materials: conservatorship of the person of Joanne R. and conservatorship of CO. Both of these cases are LPS cases, and they both stand for largely the same proposition, which is that that there has to be a voluntary, knowing, and intelligent waiver of a right to jury trial by a proposed conservatee in an LPS conservatorship. But there can be harmless error. So, I commend you to read those, even though we're out of time. I do want to mention in the Q&A, Terry Magedy had a very helpful point on the Riverside case, that it's important for folks to know that the decedent in the Riverside public guardian case died in 2016 before the state Medi-Cal recovery laws changed effective January 1st, 2017. So thank you, Terry. Glad to know you're paying attention.
Yep. Thanks, sir.
All right, so thank you very much, Nick and Scott. This was great and certainly brought me back up to speed on some of these cases that I should now get around to reading. And so again, if anyone has any additional questions, please feel free to email Nick and Scott, and we look forward to seeing you next month.